detailed written submissions, which is at volume 4. I don't propose to read at length but some essential aspects which I thought can supply by way of a addition to the arguments made before your lordships.
Which volume are you
Before I
referring
do
to?
that, this is volume 4. PDF, it's a page, it's a separate written submission on behalf of the Attorney General for India.
That's volume 4.
That's right. And then I handed over a 2-page note on the last occasion with the summary of my submissions.
Your opening arguments.
Yes, yes. Which company? It's 61 years ago, we had Puranlal Lakhanpal wanting to
Whether he has any health problem.
Oh my God.
Not a very good compliment for me, man.
kept others alive.
Brother Gavi got worried, because he noticed that the same position persisted for 30 minutes.
Fortunately, he was the only one. Fortunately for me, he was the only one.
Fortunately, he is.
Very good.
Yeah.
Please. In continuation of my summary, your lordships have been taken through the whole historical narrations. And in matters like this, it's very difficult to capture their entire history. Through a list of dates narration, we want to communicate to the court what exactly happened for a period of 5 momentous years before 1950. And they convey only a very telescope point of view. And a large amount of literature which is available to all of us to say how this momentous process took shape. Through a variety of efforts and engagements and ideas and conglomeration of thoughts. But by and large, the history has been brought before your lordships. But for the narration of history, the understanding of not only Article 370, but with the constitutional integration process would have been incomplete. And that's where the detailed list of dates narration with the learned solicitor occupies an important space. Now, they said 61 years ago, Puranlal Lakhanpal wanted to contest an election. Now, his dream has come true. He can contest an election in Jammu and Kashmir. He had to wait for 61 years for all of us. All of us are Puranlal and Lakhanpal, in a way. So this is a grand contribution to what one may say, but it's a very significant historical constitutional process that has taken place in the history of India. Now, why do we have to look at the historical narrative? Is that, of course, both sides would like to place a certain perspective on why a certain course of events alone are important. If you look at the constitutional integration process of the rest of the country and compare it to the constitutional integration of J&K, the historical narrative shows that there is no fundamental distinction at all. is the political compulsions which happened in the context of J&K made a very slight deviation. And that deviation is, again, I would call a formalization of the principles and the procedures for integration. Article 370 is nothing but the outcome of the formalization of the principles and the procedures for integration. Well, the rest of the country had gone through all that process. Union of states, merger of small territories, and the idea of a constituent assembly and framing a constitution of their own, all that process have gone through. But since there was little intervention, which is a political historical fact, Article 370 had to intervene. And if you try to attribute to Article 370 any other purpose or intent, then I think we're fundamentally mistaken. So we are asked to go back, I would probably ask you a lot to go back to 1949, 1950, and look at from the point of those who are engaged in framing Article 370, and with the visualization as to what would happen soon thereafter to the integration process of Article 370. Instead of that, we are sitting today, almost 60, 70 years later, and trying to imagine into Article 370 what contemporary context want us to imagine. I say that imagination to a large extent is forbidden. So we have to look at it from the text and context and the intent and content of Article 370. Let me quickly formulate my understanding of Article 370. I don't propose to read in extent so many of the judgments which have looked into Article 370. If your lordship kindly turn to my written submissions. Beginning. Page PDF, internal page 27 of my written submissions. And please turn before that to page 30, paragraph 9.
30.
The three dimensions of Article 370. A, you'll also have that page. A, enabling Parliament to legislate in respect of matters in para 1 and 2 of subclauses B of clause 1 of Article 370. B, application of the provisions of the Constitution of India, subject to exceptions and modifications of clause 3 of clause 1 of Article 370. And C, termination of the role of Article 370 under clause 3 of Article 370. These are the three dimensions. Then the requirements of consultation, concurrence, and recommendation, as the case may be, are the processes to be followed by the President. And I think for the purpose of our understanding, it's unnecessary to go into the question of concurrence and consultation, etc., and the distinctions. But since we are debating on the proviso to clause 3 of Article 370 and the recommendation clause, we need to place some attention to that. In my understanding, if you Lord kindly see the exceptions, modifications, additions, changes, power is, I think, virtually available in the entire spectrum of the Constitution of India in different contexts and for different purposes. But more prominently, when you come to the 5th and the 6th schedule, the legislation making power of the governor has been noticed by this court on more than one occasion, and I'll place only one recent judgment. Kindly turn to paragraph 10. At page 30, this is the Constitution made judgment on the powers of the governor under the 5th schedule. Paragraph 39 at page 30, it begins at page 30. Your lordships may skip forward to the next page and turn over to page 32. middle of that page, page 32. There's a sentence beginning, the extent of the legislative power of the governor. The extent of the legislative power of the governor under Section 92 of the Government of India Act 1935 in making a regulation for the peace and good government of any area conferred on the governor in the words of Lord Halsbury, an utmost discretion of enactment for the attainment of objects pointed to. In that case, the words which fell for consideration Judicial Committee by the power of Parliament of Canada to make provisions for the administration, peace, order, and good governance for any territory, not for the time being included in any province. It contended that if any legislation differed from the provisions in England had been made for the administration of peace, order, and good governance, the same could not be sustained as valid. That contention was not accepted. Then kindly turn over to the next page, page 33. The sentence beginning, applying the law, the middle of the paragraph. Applying law to an area is making regulations which are laws. So the power to apply laws is inherent when there is a power to repeal or amend any act or any existing law applicable to the area in question. The power to apply laws is really to bring into legal effect sections of an act as if the same act had been enacted in the entirety. Application of laws is one of the recognized forms of legislation. You'll also find in Article 370, the application principle is virtually distributed in Article 370. I just presently read that. So the application principle of laws are recognized forms of legislation. Therefore, I would probably say that Article 370 conferring power on the president is not in the nature of an executive power of the president. The executive head is conferred a legislative power, a very extensive and wide power. The power to modify a parliamentary law, the power to subject a constitution to modification is a very vast power. And that's conferred on the president not as an executive head. And therefore, in order the president is enabled in exercising that power, we have only those processes to be followed, concurrence and consultation. So if the scheme was to have a provision to facilitate and aid the constitutional integration process, we need all that to put in place. The comfort and the aspirations also to be not to be compromised, and therefore you have a concurrence and the consultation.
Mr. Tony, if we accept that position, is something which we put to the other side. What has been the practice and the convention is something different.
No, that practice in fact flows from what the president is expected to do in order to complete the process of integration, the constitutional integration process. It is not linearly, unilaterally flow from the deliberations of the Constituent Assembly of J&K.
Oh, we understand.
It was not a sole authority, yes.
We understand your argument to the extent that there were conflicting views expressed in the Constituent Assembly, which is quite you have pointed out, or what was pointed out. And what we have today is Article 370 as it stands in the Constitution. So we have to interpret that and apply that.
Yes. We don't kindly now turn to page 36. But we try to understand if this is a constitutional integration process. And the Constituent Assembly of J&K will play a role in the constitutional integration process. Now, how do you really make that happen? So I said the two important elements of 370, namely extending the provisions of the Constitution on the one hand, and enabling Parliament to legislate in the meanwhile, as the Assembly is in the process of drafting a constitution for the state of J&K. Very essential, important steps of Parliament in the meanwhile will legislate for the state of J&K. and the extension of provisions of the Constitution are equally important. They're the two important limbs. If the two important limbs in the hands of the President, and a terminus point will have to arrive at some point of time. I try to imagine that if Article 370 did not have clause 3 at all, it's impossible to think of a provision like this without a terminus point. Because it is not to serve a perpetual aid and advice position for the state of J&K through extending periodically, or what has happened over a period of time is, what the President has done is by updating various provisions of the Constitution by issuing various constitutional orders. The updating exercise went on till recently. Beyond the CO 54 1965, by which time the majority and important provisions of the Constitution were extended to the state of J&K. Beyond that, except on 2 occasions, it became contentious. They are merely updating exercises. So if Article 370 was to be conceived as a permanent updating exercise, one would have wondered why it should have come at the time of enactment of the Constitution or constitutional integration with J&K. It could take an entirely different shape. So that was certainly not the intention. So if a terminus point has brought in, and that power has to be necessarily vested in the President. Now Article 370 begins with a non-obstante clause. I understand, notwithstanding anything in this Constitution, also ours Article 368. Anything done within the scheme of Article 370, anything and everything done by the President, doesn't admit of any role for Article 368. So therefore, when Article 368 does not come into the scheme of the Constitution, the argument that during a President's rule in 356, you could not have probably taken any measure as reversible or irreversible without treading the path of Article 368 and misconceived. So if the realistic understanding of Article 370 was to complete a scheme, let's say at one level, enactment of the Constitution of J&K to the deliberation of the Legislative Constituent Assembly, and it must come to an at that point of time. And if it came to an end by that point of time, because sections 3 and 5 virtually captured the essence of constitutional integration, and nothing more required to be done after section 3 and 5 becoming the part of the constitutional document. It hardly matters whether you call it today the Constitution, we not get into the question at all. Therefore, if the integration process contemplated came to an end by enactment of section 3 and 5 of the Constitution of J&K, that's at one level. At a different level, if thereafter President has issued various orders in exercise of powers under Article 371D, and if I am right in saying they're all essentially updating orders, except those 2 controversial orders, where Article 35A came, I ask myself a question: is the President precluded from taking stock of all that has happened under Article 371D and say, what shall I do with it today? That today can come at any point of time. There is nothing, therefore, in the scheme of Article 370 enabling or injuncting the President to ask this question. She is entitled to ask this question at any point of time. At any given point of time, if there is a trigger which facilitates and enables the President to take stock of the whole situation. So COs 272, 273, which are preceded by stock-taking authority of the President. The President has taken stock of whether what shall I do with Article 370? Should it continue or should it be called to have served its purpose and terminate it. If that authority of the president is untrammeled, the measures taken by the president to deal with looking for aid and assistance measures in terminating it, coupled with what the parliament ultimately did in dealing with a very vast question of bringing peace and restoration to the state of J&K. So we are trying to tell you, Lordship, that justiciability probably will not come in. Now, let me try to understand why the J&K, the Constituent Assembly, was given only a narrow power of recommendation. Well, yes, it was necessary to have the recommendation taken from the Constituent Assembly, but the necessity does not enlarge the scope of the role given to the Assembly, which is a very narrow role, namely a recommendation role. One would probably be able to argue that if the Assembly having dissolved itself, the proviso probably would have expired on its own. It's no longer operating. If it's no longer operative and cannot be operated at all, then can you say as the tail cannot wag the dog, etc. Although it is figurative, metaphorical. But what I mean to say is this: the president lose the authority and power available in the Article 370, Clause 3, to bring to a close the entire scheme of Article 370. I would say the president has not lost that power. In the presidential poll case, question was whether, by reason of the fact that the Gujarat Assembly was dissolved, I presently play that citation. Gujarat Assembly was dissolved, and for the conduct of the elections of the president, the electoral college is incomplete. And the election will be complete in a certain period. That's a mandate of the Constitution. But you can't do it now. Your Lordship in a 140 reference said, if the mandate of holding an election within a period now becomes impossible without an electoral college being available there, does not relieve the mandate from being complied with. So therefore, in certain circumstances, certain what called facilitating or what is called the recommending role of the Assembly is just not available. The President's authority under Article 373 can operate without any further assistance from any other authority. The President could have said in under Article 371D, which is precisely what has happened here. He did not require any further assistance from any other authority. But by way of abundant caution, in continuation of what happened earlier under Article 371D, the President follows the same footsteps now, substituting Legislative Assembly in the place of the Constituent Assembly. So whatever gap, a suggested gap may be perceived, President says, now I'll fill that gap. There are several situations when such conditions, preconditions of performance cannot be performed. It's called the doctrine of impossibility. So therefore, the performance is not relieved. Performance will still be done. The conditions may be ignored. So therefore, if following an earlier precedent of Article 371D invocation, we had the substitution of Legislative Assembly in the place of Constituent Assembly, the President follows suit. Please also bear in mind when the role, I lost it.
See, when you refer to subclause D to Article 371, to the government of the state. Now, if one has to take the concurrence of the government of the state, read clause 3 of Article 370. as giving complete and absolute power to the president will be virtually going against the entire object and purpose of the enactment, because otherwise clause D and the proviso says concurrent state governments becomes a formality. When we read that article, when we read clause 3 to article 370, we cannot ignore the article 370 clause 1, including D and the proviso, state government.
Right. Right.
Not to the Sadr Riyasat, but Council of Ministers. Governor with the Council of Ministers.
Let me try to look at it from that angle.
So if you're going to read clause 3 of article 370 in isolation without reference to subclause D to article 371, and then argue that this absolute power given, or absolute because there's an integration which has to be done, will it not be in conflict with, or not be in terms of the entire purport of the article itself?
The perceptions about this conflict arise because we are dealing with a provision which was meant to work during a certain period. And during the period, how it would have worked. And since it crossed that period, we have all these questions which are apparently in conflict. So therefore, if you go back to a period prior to 1957, and imagine what would have happened if the Constituent Assembly had recommended to the President to dissolve or to delete Article 370, partially or fully. Question would have been entirely different. So because it did not happen, we have to put in position a certain understanding as to make it, give it a meaning and context till ultimately President takes stock on that. So that giving a meaning and context and relevance will flow from what has happened over a period of time. And what the President can ultimately do in our understanding of the role and relevance of Article 370. And that's the most fundamental thing. Is the role and relevance of Article 370, regardless of its exercise over a period of time, is clearly understood by the President now. Then by what other normative yardstick about the relevance of Article 370 will the court judicially scrutinize the exercise of power by the President today?
Yeah, but in this case, is there any President's proclamation excising power under clause 3 to article 370? Saying that I'm abrogating article 370.
I'll just come back. Can I come back to it by after reading of some part of in the line of my presentation? Kindly come to, let me complete this and come to your Lordship to answer your Lordship's question. Page 36 of my written submission.
Page 36.
We're talking about paragraph 12. We're talking about the recommendation role. I would just want to finish that part of the argument and then try to come back to this. Kindly turn to page 36, paragraph 12. Because if we try to extol the recommendation role beyond a certain level, then we are rewriting Article 370. So the recommendation role is a very minimal role. And how is it being understood in different contexts? We have
does a recommendation postulate a positive recommendation, or does it mean just any
it is
opinion?
an advice. It is an advice. So it's an advice to facilitate and enable the President to find as to whether Article 370 has served its purpose and to close it. So the main whole clause 3 of Article 370 is to render Article 370 inoperative.
But what
In
happens,
that context,
suppose there is a Constituent Assembly.
yes.
We'll not go into this issue of the Constituent Assembly and the Legislative Assembly. And the Constituent Assembly recommends to the President, do not abrogate Article 370. Is it open to the President then to override the advice?
That power of recommendation is not available to the Constituent Assembly.
Sorry?
The Assembly has to only recommend the President in regard to rendering Article 370 inoperative. The President seeks that advice from the Assembly. The Assembly will not say, I have my different thinking on Article 350 and I'll ask you to retain 370 the way we want it. So therefore, the advice, the recommendation
is not just an opinion.
Yeah.
When the Constitution uses the expression recommendation, it means a positive decision, because Article 370 uses different phrases. It uses consultation, it uses concurrence, it uses decision, and it
You're
uses
right.
recommendation.
Exactly right. So therefore, the use in Article 370 of all these distinct expressions, concurrence, consultation, have their context. So therefore, recommendation is seen as an entirely distinct idea altogether. If the Constituent Assembly was to,
contending that even if the Constituent Assembly were to say that please don't abrogate 370, the President can still abrogate 370?
she can. Recommendation is not binding on the President. Therefore, it is recommendation. It is not concurrence. So concurrence for the purpose of concurrence for the purpose where you get the provisions of the Constitution extended stands in a different thing altogether. Consultation where the Parliament will enable to enact during that period. Consultation. So recommendation occupies that it comes at the end of the day when all the parties have understood that the job of 370 is done. What shall I do? The President says, let me know what I shall do now. I want to probably say, I've taken stock of all the presidential orders issued. The constitutional integration process is over. Now, is there anything left by way of invoking Article 370 or extending the provisions of the Constitution of India to J&K? That question will have to be necessarily asked. When that question is asked, what is the role of the Constituent Assembly? So if the 370 had envisaged a larger role, that would have defeated the very purpose of constitutional integration. Therefore, the only relevant
Mr. Attorney, the use of the expression recommendation is not by itself dispositive of the content of the expression as to whether it is merely an advice, whether it is a condition precedent. I'll give you two examples. See, there are two examples in the Constitution where the word recommendation is used. Article 109 and 117. Yes. Article 109 deals with money bills. A money bill, after it is passed by is not introduced in the Rajya Sabha. Always introduced in the Lok Sabha. After the bill is passed by the Rajya Sabha, by the Lok Sabha, it is transmitted to the Lok Sabha, to the Rajya Sabha for its recommendations. Those recommendations are not binding on the Lok Sabha. It may either accept them, it may accept them in part, it may reject them. That is what Article 109 says. So in Article 109(2), see the way it is worded. The recommendation of the Rajya Sabha doesn't bind the Lok Sabha on a money bill. Now see 117. 117 says that a money bill cannot be introduced except on the recommendation of the President. See 117. A bill or amendment making provision for any of the matters specified in subclauses A to F of clause 1 of Article 110, I'll go to 110 in a moment, shall not be introduced or moved except on the recommendation of the President. Now, in Article 117, the same word is used, recommendation. Recommendation is mandatory. You can't move a money bill unless there is a recommendation by the President. Now comes 370. There are many other provisions of the Constitution. I think, if I'm not mistaken, in my dissent in Aadhaar, I had analyzed those provisions of recommendation. Now see 370. It says provided that the recommendation of the Constituent Assembly of the state
Shall be necessary.
shall be necessary before.
That's right.
Shall be necessary and before. So it's a condition precedent and a condition in terms of time. It can't be a post facto recommendation. It has to be before. What is the reason for it? There has to be a recommendation by the Constituent Assembly for the abrogation of Article 370. And second, that recommendation has to be before the President decides to abrogate it. Therefore, to say that, this recommendation is just an opinion, it's not binding on the President.
My submission is not to slight that recommendation role, but I say it's still only a recommendation. Let me try to explain. The necessity of having a recommendation does not add any further content to the role of recommendation. There is a procedure which is required because during the constitution integration process.
So your
So many
contention is that
parties
you
were
have to have a recommendation.
Yes.
And it's not binding. It may be a positive or negative recommendation. The President can override whatever is said by the Constituent Assembly.
No, the reason why, therefore, what I would call a minimal role of recommendation given to the Constituent Assembly is in the context of one, the scheme of Article 370, and that being part of the larger integration process, can a body like the Constituent Assembly of J&K can have a final say on Article 370? It is not a constituent body of a Parliament of India. It doesn't have all that attributes and powers. So the recommendatory role has been assigned in the context, keeping in mind that once the constitutional integration process is completed, in the understanding of all the parties involved, there has to be a terminus. And to bring the terminus to a completion, then the role of recommendation is assigned. Otherwise, the Constituent Assembly could have been probably given the powers of consultation, concurrence. Why is state government coming into Article 370 at all? So it's only at the end of the day when you have done all that job. It's a stock-taking exercise. And it will probably envisage that you will do it before the constitutional integration process gets over.
What is the sequitur? Are you therefore contending that therefore, since this is purely recommendatory, therefore the absence of a recommendation also doesn't make a difference? Is that the submission or what is the submission?
I'll personally try to address the question. That's only when
103.2, yes.
there are different. Oh,
Qualifications. Wherever they want that opinion or recommendation should be acted upon, they say so. It will be referred to the commission will give an opinion, and then it says, and shall act according to such opinion, which is missing in
act according to.
Just my note, I have mentioned, I didn't read it, but the President of India being bound solely by a body which is outside the Constitution of India, Lord, may perhaps not be the correct interpretation of our Constitution. That if it says yes, he can do it. If he says no, President cannot do it. Because Constitution of Jammu and Kashmir is beyond and outside our Constitution.
Clause D does the same thing. It says that other provisions of the Constitution can be adopted subject to such modification and exceptions. If they relate to the instrument of accession, consultation. Anything else, concurrence
Of the state government,
of this
not,
concurrence.
not,
there.
not Constituent Assembly.
Not to the assembly.
No, but then if the Constituent Assembly was not in existence, then it has to be placed before the Constituent Assembly for its decision. That means even in the case of the operation of clause D, read with subsection with clause 2, the Constituent Assembly is given the overriding power, even in relation to the President.
Till it survives, till it.
There's slight difference. See, you can't say when when Article 370 itself refers to Constituent Assembly, you can't say that this Constituent Assembly is outside the Constitution. It's within the constitutional framework because it refers to it. Yes, your argument that once the Constituent Assembly is no longer there, what will be the position with regard to clause 3 to 370 is something which we'll have to examine. With reference to the procedure you have, with reference to, because the judgments itself, many of the constitutional bench judgments itself says we are not examining that issue. We'll have to examine.
No, only worry is, only with permission of the learned AG, the worry is, well, suppose this exercise would have been undertaken in 2007, in 57, when Constituent Assembly was in existence. Suppose it would have recommended that don't abolish or don't abrogate or apply with modification that none of the provisions of the Constitution of India would be applicable or never apply fundamental rights with that modification. Lord, I'm putting a question to myself, the President of India will be denuded of its powers, Lord? Was it intended that by not recommending not to abrogate, it would become permanent?
We have taken that
Put
argument.
it in other words.
That proviso will no longer be applicable after the Constituent Assembly is not there, but that will not deprive the President of his power under clause 3.
To put
We have
it in
taken-
other words, if the object and the role of Article 370 is essentially and fundamentally a constitutional integration process, anything which emanates from the assembly, to the contrary, as a way of negation of the integration process, would be forbidden under the scheme of Article 370. You can't have a negation there.
Mr. Tony, you extended that argument,
Yeah.
therefore the questions arose. You extended the argument to say recommendation only means advice and even no advice. Suppose the Constituent Assembly was, that's assuming that the Constituent Assembly was,
Therefore,
There-
I quite see. Therefore,
that,
what I'm
that
trying-
part, the extension part is the one which is.
Therefore, we have to probably understand the context in which why this provision was at all enacted. The constitution integration process repeated was the only mantra under Article 370. And everything around it revolves around it. 371 A, B, the Parliament is enabled to legislate, extension of provisions of Constitution, they all revolve around this central theme.
See, the only thing is in relation to Jammu and Kashmir, one thing is very clear from reading Article 370. It expressly recognizes the instrument of accession. Categorical recognition of the instrument of accession in Article 370 itself. Second, a categorical recognition in Article 370 of the process of the formation of the Constitution of the state of Jammu and Kashmir. Third, a categorical recognition of the status of the Constituent Assembly of Jammu and Kashmir. So therefore, it's not that these were instances which were taking place as a part of the realpolitik in that state. The IOA, the Constituent Assembly, the process of constitution formation in Jammu and Kashmir, they are expressly recognized in Article 370.
You're right. My editor is
So
small
they have been
caveat.
conferred with a certain constitutional recognition, if not a constitutional status, a constitutional recognition in Article 370.
I just want to enter a small caveat because the historical narrative about what happened in the rest of the country towards constitutional integration. As I said, essentially the process was one and the same. Constituent assemblies.
You are right,
formation
Mr.
of
Attorney
states.
General. You are right in Mr. Attorney General to the point that this was in aid of constitutional integration.
Yes,
And as we see that integration was taking place by and by
yes.
from 1957 right through to 2019. So subjects which were completely excluded to the Parliament were brought in within the purview of Parliament. That was also that was a clear understanding of the constitutional movement towards greater integration of Jammu and Kashmir into the Republic of India and the Dominion of India originally, then the Republic of India. So there was undoubtedly a gradual and imperceptible integration apart from the unconditional accession to India, which we saw right at the outset in Article 3. There's no difficulty about that. But the only point really is this, that there are two ways of looking at Article 373. If the proviso can't apply, we keep 367 apart for a moment. If the proviso to Article 373 cannot apply, does that mean that the power under the substantive part of 370 is
Is lost.
completely denuded or lost?
No. The answer will be no. I'll try to.
That's the
The power is
issue
not
which we have
lost.
to.